So good morning, good afternoon, good evening. Thank you for joining us for this webinar, Protecting Your Know-How, Your Secret Weapon, between eSilo and B4Patents. Well, we're going to record this presentation for future reference and replay. So what will we discuss today? We're going to talk about the different types of risks and data loss that can affect your competitive advantage, mitigation to those risks, and introduction of trade secrets, the solutions that we have, as well as some questions and answers. To briefly introduce myself, my name is Christo Angelov. I'm one of the founders for B4Patents. I have been in the cybersecurity space for approximately 18 years. And we'll talk about the technology and cyber risk aspects when it comes to information protection. We also have Kathy with us. Kathy, would you like to introduce yourself?
Thanks, Christo. I'm Kathy Myron. I'm the CEO of eSilo, and we're a data backup and cybersecurity company focused on helping small to mid-sized organizations understand how their critical information can be at risk and how they can prevent those types of risks from happening, like cyber attacks, and how they can quickly recover after they strike with the right level of disaster recovery and backup plans. Gil, would you like to go next?
Sure, thanks. My name is Gil Perlberg. I'm also one of the founders of B4Patents. And I've been doing IP consulting for the past 15, 20 years. And we started B4Patents because of issues related to trade secrets and competitive advantage that we want to discuss here with you. And we also teamed up with Kathy and eSilo because we think that they're all connected. And that's what we want to discuss and show you here. Caitlin? Next slide. So what we started realizing B4Patents is that when we talk about competitive advantage and IP risks, the biggest risk is usually trade secrets or compromise of very important information that is key to a company's competitive advantage. And that is by far the most important IP assets most companies have or most businesses have. Even if they have no patents, they have competitive information and they need to maintain it or keep it. And the second thing that we've learned is, and it's not ours to say, it's something in the literature, that most trade secrets or important know-how is compromised by internal employees or internal members. People have the keys to the office and do this usually by mistake, usually by ignorance. They just don't know, don't realize what is important, how to discuss things that are important, and we call it ignorance. And the thing about ignorance we'll discuss in a few minutes, it's training. There's a more complex issue, which we call inevitable. And that is when we're doing business, like in the picture here. Sometimes we need to share confidential information with others. It's part of doing business. And sharing of information, of confidential information should be done carefully, should be documented, recorded. And that is part of what we're going to discuss as well. And then there's the third of those three, which is intentional or malicious, which we will not discuss. That has to do more with technology and legal, less the focus of our presentation today. So ignorance and inevitable. And what we want to do is discuss a few scenarios, situations that we don't always realize that we are at high risk to compromise our competitive advantage or competitive information. And consider this situation where we have an employee joining a company. We call it the employee life cycle. And consider 5 stations, maybe 5 years. At the beginning of year 1, when the employee joins, she signs an employment agreement that includes a confidentiality clause. And in the first year or first period, there's a lot of training going on and a lot of confidential information is shared with the employees so that they can do their job. That's needed. And in the middle phase, in phase 3, This is sort of a well-established employee, been in the company a long time, knows most everything about the company. And then stage 4 represents a situation where the employee is starting to think about moving on. What happens when an employee moves on? Usually they go on the interview with different companies. And during the interview session, they will be asked, they will share what they know, what they've been doing, what they're experts in. They want to make a good impression on the potential employee. And this can happen a few times because sometimes they go to multiple interviews before deciding that they want to move on. And then they come back to their company and say, I've decided to move on. And they go to a process that includes an exit interview. And in the exit interview, they remind the employee of the confidentiality clause that was signed 5 years ago. So not really effective at this point because all the trade secrets were already discussed. So there's 2 events here that we call trade secret events. The first is when we hire somebody and it doesn't work out. Might be because the employee decided to leave after a short time or the company decided it's not working out. But it happened after a lot of information was already given, provided. And the second is a long-time employee looking for another job. And when we tell them at the end of the journey, it's not really effective. So we have to do something different throughout the employee life cycle to protect our competitive advantage, to protect the livelihood of everybody involved in the company. So that's one situation and scenario. Caitlin? So there's 2 others, and I'll let Krista and Kathy describe them. Krista?
So when it comes to unintended information disclosure and the general use of technology, there are many different risks that we can talk about, and there are many different avenues that information may leave the company. But one of the most common that is used within the business world and is almost overlooked from a risk perspective is the use of email. Once an email leaves your inbox and is distributed, you have very few controls in terms of what happens to that information. First and foremost, they can be sent by mistake to the wrong recipients or to a larger audience that isn't intended to be a recipient of that information. They can then be forwarded or used in ways that we did not intend. So email in the first place was never designed to be a secure messaging protocol. It was only intended to be used for sharing of basic information. That is clearly not the case in the current corporate environment. And it's really useful to think about what could happen to an email, both by unintended recipients and intended recipients and how that information is used. And Kathy, would you like to talk about the other example?
Sure. And I guess, Christo, the other thing I would add on email is that a lot of email communication is not encrypted. If you've not gone ahead and specifically turned on those settings from a security perspective, you have to assume that that email can be visible to hackers and third parties. And it may not happen on your side, it could be the recipient and their lack of email security controls. So something to keep in mind. The other place that I think we have to be very aware of when it comes to potential information leakage is in the use of various cloud tools. And they're not even just cloud tools, but IT tools, marketing tools in general. And I use the example of ChatGPT because generative AI right now is getting so much buzz and attention. And it can do so many great things as far as helping you to synthesize a large volume of text or do research or come up with maybe new ideas to solve some old problems. But the challenge with ChatGPT and any other of these AI-powered tools is that most people don't read the privacy policies of these tools before they use them. And it's very common for cloud tools to do a lot of data capture and logging of transactions or inputs. And if you look at the recent Samsung data breach, where an employee of Samsung had put some code into ChatGPT in an attempt to debug that code or figure out what was wrong with that code, and that resulted in the unauthorized disclosure of that code to other users of the ChatGPT platform. And so we use that as an example, but think about when you use an email marketing system like MailChimp. You're feeding it your customer list or your prospect list, or you use a cloud-based CRM or customer relationship management system, and you have a whole bunch of different information about your contacts, the communication back and forth, potentially attachments that get auto-logged to those systems from emails that get sent. And you can see that the potential for information disclosure gets really wide really fast. So not to say that you shouldn't be using these tools. I think these are fantastic tools to help organizations be more productive, but you have to understand the privacy posture of these companies, what the terms of service are, what the specific content that they're going to be logging for you, excuse me, and use them for only non-sensitive information. And so to the extent that you can anonymize anything that you're going to feed into one of these AI tools, I would highly recommend you consider doing it and never use it for anything that could potentially be deemed a trade secret or confidential. Next slide. So the third thing that we wanted to bring up when it comes to cloud tools and just some common misperceptions or mistakes that we see companies make is that a lot of the online storage gets used as a quasi backup tool. And the first thing that I would tell you is that whether it's Dropbox or Google Drive or OneDrive or pick your poison, they're fantastic tools for productivity, but they were never designed as a backup or archival tool. And so you need to understand what they were built for and use them appropriately. So the tools that I mentioned are categorized as cloud synchronization tools. They're going to help you get copies of important documents and files off of your laptop or computer so that a second copy lives someplace else. And the classic example would be if you spilled coffee on your computer today and you fried the hard drive, you want to make sure that you're not going to be losing, any of that data. They do fulfill to a certain degree a safety net. They provide a safety net against that scenario. The problem is if you're looking at anything more sophisticated in terms of data protection and data loss, those are not great tools. And the example that I would use is the mountain climber that we've got here on the right. When you have a real business grade backup, you have fixed restore points at certain times of day, at certain frequencies, so that if something happens, like you spill coffee on your hard drive, or you get hacked and are a victim of ransomware and the entire contents of that computer are completely scrambled and unusable, you know that you can roll back your history to a specific date and time in the past before that attack or that event occurred. So that's going to enable you to recover all of your information synchronized up at a particular point in time. So that gives you control over versioning. That gives you control also over retention, where you can say that we're going to retain 30 days of history, 6 months of history, 7 years of history. And your legal requirements are going to vary based on the type of information that you have, and the jurisdiction where you operate, or jurisdictions, will determine how long you need to keep that data for. And backups and archives are a fantastic way to do that, but you have to make sure that you're using the proper tools in order to do so. The last point I'll just make on this is that those cloud sync tools like a Dropbox and a OneDrive, they're very vulnerable to hacking and malware, meaning if you experienced ransomware on your computer and it jumbled all of your files, that's going to immediately sync to your cloud repository. So those cloud versions of those files will also be corrupted. And there is a level of history that you can roll back to, but as a user, you can't control that. That's something that Microsoft or Google or Dropbox, they're in control of the versioning. So again, just a word of caution if you're going to use that for anything other than productivity. Next slide. Gil, do you want to take us through?
So another scenario, and we'll be going back to what Kathy described here also, is a scenario of joint development between two companies, company A and company B, usually not necessarily the same size. And the time T0 is the time that the project starts. And the point here is that we want to be able to differentiate between background IP and foreground IP. What was known to each company before the joint development started and what happened afterwards. And usually years later, we come to some discussion, or not usually, but often. And the question arises, what belonged to who before the project started? And also, while the project is ongoing, what belongs to whom? So clearly, before the project starts, I work with companies and advise them to define and document and store very carefully everything that was theirs, so that will be clearly identifiable 5 years from now, for example. As the project is ensuing, I suggest to document what was their contribution to the project. And also, the project will end one day, but there will be derivative products from it. And there will be discussions, who owns the derivative products? Knowing who has the background IP, who participated and contributed to the foreground IP will help resolve a lot of these questions. And this goes back to what Kathy was saying before. You have to keep the information. Kathy?
Yes, because one area where backups can really be helpful is in proving who had what IP originally, right? So if you keep an archive for, let's say, several years, you would potentially be able to demonstrate that in my files, we had this documentation, so we can demonstrate that we brought this to the arrangement. Next slide.
Thanks, Kathy. So another issue that we often find ourselves in is when we go to an event that there's legal issues involved, there's problems, and we want to get recourse from the courts. And many times, the injured party cannot get any relief, even though it's clearly proven and demonstrated and admitted that one of the parties took information or compromised the information that was very important. And the reason they cannot get relief is because the information was not treated as a trade secret. So to get relief from the courts for trade secrets misappropriation, you have to be able to demonstrate that the information was kept as a trade secret. Specifically, the weak point is what's called reasonable measures. You have to be able to demonstrate that you took measures to protect the information. Many companies rely on a confidentiality clause or an NDA, and that is necessary, but the courts do not consider it as sufficient. You need a confidentiality agreement or confidentiality clause and other steps appropriate for the information that is kept, such as physical assets or physical protection or passwords or markings or training or all of the above, in order to demonstrate that you took reasonable measures to protect your trade secrets. Otherwise, there were no trade secrets. Kathy, you have anything to add here?
Yeah, the thing that I would say is that oftentimes we talk to companies about the crown jewels, and that would typically be the most valuable information retained within their systems, critical to their business. Now, that should absolutely include trade secrets, but it may also include things like sensitive, personally identifiable information for which you have an obligation to uphold the confidentiality of. And so when a company has identified where their crown jewels live, they can direct the majority of their cybersecurity focus and resources on protections for those systems and the flow of that data across systems and between people and organizations. If you haven't done that exercise to identify what is most important to protect, it's very difficult to then demonstrate that you've put in place these solid protective measures that Gil was just talking about.
Thanks. Next slide. This leads straight into the next slide about how you secure a competitive advantage. So there's the crown jewel. Coca-Cola recipe is one example. KFC recipe is another example. But both of these companies have many, many, many trade secrets. And they take a lot of precautions to maintain control of other confidential information that help them keep their companies thriving. So the crown jewel is one, but there's a whole lot of others. And I'll give you just a couple of examples. And sometimes it's not related to technology and or crown jewels in specific, but smaller things. For instance, we worked with a company who provided IT services. And I'm talking about technology and configurations here. And they had a very good process for setting up systems such that it would be fast and very effective, and it allowed them to give very good service. How they did the configurations of the systems that they installed was their trade secret. And it worked for them. It gave them a competitive advantage. Only a few people knew the recipe, and it was not shared. This is not technology that they developed per se, but it's processes and procedures that were important to them. You can have data of different types. Some of them you're obliged to keep protected because it belongs to other people. And sometimes it's your own. But this is not protected by patents. And there's no other ways to protect it other than by procedures, means, and as trade secrets. Kathy?
When you think about the ways in which you can lose that competitive advantage, I think you have to think broadly about the different types of threat actors. So the threats don't always just come from external places or people trying to do you harm. And I'm thinking about corporate espionage, hacktivism, hackers that are out to just ransom you for money, right? That's certainly a component of it. But you have to think about also what we call malicious insiders. So perhaps it's the employee in stage 4, if you remember back to Gil's chart, where they're a little bit unhappy. They maybe have felt like they were slighted, perhaps for a promotion or some other situation at work. And now they're potentially out to do some harm or out to take something, take their client list, take their contacts with them to that next job. So those are folks that we would categorize as malicious insiders, and they're very difficult to detect, especially because the level of access to that information that they have is legitimate. So it's really hard to determine what behavior is normal business activity versus potentially somebody downloading a whole bunch of information before they leave their employer. And then the other component that Gil touched on as well is perhaps the accidental loss of information. And so that can come from existing employees, folks making mistakes, sending out emails to the wrong people, as Christo mentioned. But your goal from a technology and a cybersecurity perspective is to put enough guardrails around what you do in your business so that those types of mistakes and those types of intentional actions either can't happen at all, which would be preventative controls, or if they did happen, something suspicious, something unusual, you have a very quick to detect and respond process for how you then deal with those situations immediately after they happen. Next slide.
So every company I've talked to, every CEO, every CTO, and IT manager tells me we are protected. We have some forms of protection. We're okay. And when you dig deeper, they do. They have some form of protection. But of course, we all realize that partial protection is not sufficient. And we have to look and see if it's a surround system. Next slide, please, which is what we need. Otherwise, we really have very little other than sleeping good at night, but not really being protected. So what we're advocating is something slightly different. And we look at a surround system that starts at the top with policies and processes, where we have guidelines that management applies. And it takes to every part of the operation of the company. There's also a lot of legal issues that have to be addressed. And again, not all legal documents take trade secrets and competitive advantage information in mind sufficiently. And we review them and make sure they do. And Kathy, you want to talk about the IT and cyber guardrails?
Sure. So once an organization has defined their policies and their procedures and have evaluated their obligations through those legal contracts, they have to translate into technical controls that manifest themselves in the systems that the organization uses. And in the technology world, there's something called defense in depth. So think about an onion with multiple layers. And at the outer layers, you have your physical office, perhaps, and then your network, your corporate network, where your information and all of your assets are connected. And then you go deeper inside that onion, you have all of the different devices which are used to access your data. And then you have the apps and the data itself. So when you have this concentric set of rings and a set of cybersecurity controls at every single layer of the process, then you know that if you were to experience a breach, you have layered controls that should detect and respond to and prevent those scenarios from happening, and that you're effectively implementing all of the requirements in those policies and in those legal contracts through the technology controls.
So the surround system that we're talking about includes processes and policies, legal and technology, but there's always a weak link. And the weak link is the employees, the people. You can never anticipate all situations. And for that, we have the training and awareness, and we separate them because of the following. Training is sort of a one-of-a-kind event. It happens when an employee joins, it happens annually or periodically, but it doesn't happen all the time. It's not enough. It's a must, but it's not sufficient. And we put a special bubble for the awareness. The awareness has to happen all the time by everybody involved. This should be minded to these situations. And that way they will resolve problems that have not been addressed by the technology guardrails or by the legal aspects. And all this looks very intimidating and comprehensive and a lot of things to do. So next slide, please. What we've done in B4Patents is we've tried to identify the 80-20, the 20% of the things we need to do in all of these bubbles that will give us 80% of the protection. We think that that's a good place to start. And then you can go on further. Now we're calling this 80-20-100. Why 100? Because yes, we've identified 20% of all of these bubbles that we need to do. They will give us 80% protection, but it has to be applied to all the employees. We can't just apply it to a few or a subset of them because the risk spans all of the employees. And we also have to apply it all of the time, i.e. awareness. And that goes then to 360 management of all of the disciplines of the company, all the operations, and it includes legal and IT and cyber guardrails. So that is the methodology we're advocating and suggesting to people to increase their protection and to prevent trade secret leakage and to protect their competitive advantage. Kathy?
I think you covered it well, Gil. The only thing that I would add is that when it comes to cybersecurity, it's too often that training only happens on an annual basis. There are ways to put micro training in front of employees every single month so that security is something that is top of mind every single month. Because let's think about how many times you click on an email or open a link or visit a web page. So I think it's incredibly important to just make sure that you're investing enough in your staff so that this is always top of mind. Because I always like to say that folks think that technology and cybersecurity is done by some lonely IT hero or some person in the IT department. It's very easy to want to delegate that responsibility out, when in reality, every single person in the organization, if they're using a computer, they have a role to play in your defenses, and training and awareness is the best way to reach them.
Thank you, Kathy. Caitlin, questions?
So a question that we get quite often is, when would be a good time to start employing these mechanisms? Like how would we get started, and when would we start?
Krista, you want to take that or?
Sure. So really the right time to start is at the very beginning of a company's structure. Oftentimes that's not really practical because a founder's focus is very, very spread between different sets of activities. But the reality is that applying controls, especially technical controls, is really ideal at the very beginning of doing anything. That ensures that going forward, the protections that are put in place, whether we're talking about configurations or access or backups, are there in the first place and are there operating effectively throughout the company's growth and changes that it experiences over its lifetime. So starting as early as possible is ideal. Again, given that's not really practical all the time, it's always good to revisit that as often as possible. So even if you are in a place where some of these areas, whether we're talking about legal contracts, training, awareness, policies and procedures, or technical controls are not where they need to be, the right time is now. If you wait until you have some sort of an event or until you lose information or lose a trade secret, which, by the way, is oftentimes when people start really paying attention to all these different dimensions, it's often too late. And not only is it too late, it becomes very costly because you are oftentimes rushed to act. And not only are you rushed and you're paying exorbitant fees to get all this done in a short amount of time, your information is already out and you've already lost your competitive advantage. And once you lose your competitive advantage in a way that it's compromised and utilized by others, you have very little recourse to get it back. Gary, Kathy, do you have anything to add to that?
I was going to chime in just to say I agree wholeheartedly. Is the best time is to start is yesterday, regardless of how mature, how large or small your company is. But in lieu of that, one of the best ways to start is also with an assessment. So perhaps you're beginning to contemplate, well, are we doing enough to protect our trade secrets? Do we understand where they are? What I would suggest is undertaking an assessment, either a self-assessment or having an outside organization come to take a look at your policies and procedures. Do they cover all of the things that you would typically expect, both from a legal point of view, but also in terms of cybersecurity? Do we have a robust set of technological controls implemented? And if not, how do we then beef that up? And there's plenty of industry frameworks, and I'd be happy to also suggest some if you're struggling in that area to use as that benchmark. And then what level of training and awareness are we giving to our employees, either through the normal HR process or through any targeted compliance-oriented work? But going through each one of the boxes or circles, I guess, on this chart to say, how are we doing compared to industry standard? And frankly, compared to best practice, because I think where you want to be is a best practice. That's going to give you a really good roadmap to say, these are the ones where we're the weakest and we should probably start there. And I know Gil would be happy to also chime in on that as well.
I agree with everything said here, and just to further the concept we developed before, we've identified the 20% that we think are good starting points in each. First, they have to be customized for each situation, for each company. But it's good to start somewhere as soon as possible and get the ball rolling. That's the bottom line. Caitlin?
Thanks. Yeah, that definitely answers the question. But I think, although Kathy touched on it briefly, maybe I don't know if it's possible to give us some clarity on how we would start. I mean, an assessment would definitely be a good place, but I think if we're a little bit into the business already, how do we even start that assessment? That can be quite an overwhelming task.
Yeah, I'll give you a perfect example, and it ties into something that Christo said before, which is when you try to do this after the fact, when the horse is already bolted, it is a lot more difficult. So we're working with an accounting firm, And they recently had reason to believe that there may have been a data breach that originated from within their organization. And I'm trying to talk very carefully about this. And so we sat down with their technology team to say, based on the indications that you were given, right, what have you been able to research about the origination of this leak? And the problem that they had is that the level of logging and data analysis that they're able to do at this very moment is extremely, extremely limited. And the reason for that is they didn't have the right technologies, the right security software installed on all of the computers and all of the servers that would give them the data to forensically analyze activity over the course of the last several months to conclusively determine if some data was taken or shared, taken by an outsider or shared by an insider to third parties. And so, because they're in that situation right now, we're doing an assessment of their overall IT and security controls against the National Institute of Standard and Technology, or NIST. They have a cybersecurity framework. So we use that as a baseline for typical cybersecurity controls that any organization in any industry should have. So we're using that as a framework, plus a couple of things from the IRS. To then evaluate how do they measure up against that framework. And I will tell you that their level of maturity right now is extremely low because they had never undertaken a similar exercise. They had never looked critically at their own processes and controls and had been comfortable to rely on access controls and basic backups as their main methods of protection. So if I think back to the picture that Gil shared with the gate and the wide green space around it, that's a classic example of where that company is. But I'll tell you that almost every organization that we look at, there's some degree of that. So taking a holistic assessment against an industry standard framework is the best way to go. And whether you're a healthcare practice, and so you're looking at HIPAA as the standard, or you're a Department of Defense contractor and you need to look at CMMC or broker dealer and FINRA. I mean, there's a million standards out there, and it'll vary based on industry and country. But honestly, what I would tell you is that when it comes to data protection, forget the acronyms and the three-letter organizations. Good cyber hygiene is good cyber hygiene. So pick any one of the frameworks and assess yourself against it, and you'll be able to come up with a gap list pretty reasonably quick.
I think that
Thank
covers it.
Yeah.
Okay.
Yeah, any other questions from the audience, or any other things that come to mind that we wanted to share?
Thank you.
If not, I'd like to thank everyone for attending. And thank you, Eileen. I'm glad that you found this informative. We appreciate you joining us today. And hope everyone has a great rest of their day and week. And if you have not taken the steps necessary, now is a good time to start. Thanks, everyone.